Hello and welcome to the Entrant. The topic for today's discussion is one of the most relevant topics under the Indian family laws. Divorce under Islamic law holds great importance when it comes to questions asked in competitive exams. Let us start off by understanding a little about Muslim marriages. Muslim marriages, unlike Hindu marriages, are in the nature of a contract and are governed by their personal laws. Under the Muslim law, the wives cannot divorce their husband on their own accord. She can only give a divorce if her husband has delegated her right to do, or that under an agreement. However, the legislature has extended statutory rights to Muslim women to give divorce to their husbands under the Dissolution of Muslim Marriages Act of 1939. Therefore, there can be two broad categories under which the divorce or talaq under Muslim law can be divided. They are extrajudicial divorce or talaq under Muslim personal law or the judicial divorce or talaq under statutory law. The extrajudicial divorce is when it depends upon the will of the husband or wife or when it is by mutual agreement. There are different rights provided to the wife and the husband. Generally, rights to give divorce are given to the husband only. The wife is at a very lower pedestal regarding the right to divorce. Extrajudicial divorce is divided into several parts: Talaq-ul-Sunnat, Talaq-ul-Biddat, Illa, Zihar, and by the wife is Talaq-i-Tafwiz, Lian, and Khula, or by mutual agreement or Mubarat. Talaq-ul-Sunnat is also called as Talaq-ul-Razi. It is a revocable form of talaq because in this form the consequences of talaq do not become final at once. There is possibility of compromise and reconciliation between the husband and wife. Talaq-ul-Sunnat is regarded to be the approved form of talaq. This mode of talaq is recognized by both Sunnis as well as the Shia sect. Talaq-ul-Sunnat may be pronounced either in the Ahasan or in the Hasan form. Ahasan. This is the most proper form of repudiation of marriage. The reason is twofold. First, there is possibility of revoking the pronouncement before expiry of the iddat period. Secondly, the evil words of talaq are to be uttered only once. Being an evil, it is preferred that these words are not repeated. And Hasan. This talaq is also regarded to be proper and approved form of talaq. In this form too, there is a provision for revocation, but it is not the best mode because evil words of talaq are to be pronounced 3 times in the successive duhurs. Talaq-ul-Biddat is also known as Talaq-ul-Bain. It is a disapproved form of divorce. A peculiar feature of this talaq is that it becomes effective as soon as the words are pronounced and there remains no possibility of reconciliation between the parties, thereby making it irrevocable. This form of talaq is mainly recognized and practiced by the Sunni Muslims and is not recognized by the Shia Muslims. Talaq-ul-Biddat may be pronounced in a single declaration or by triple declaration. In Ila, the husband takes an oath not to have sexual intercourse with his wife. Followed by this oath, there is no consummation for a period of 4 months. After the expiry of the 4th month, the marriage dissolves irrevocably. But if the husband resumes cohabitation within 4 months, Ila is cancelled and the marriage is not dissolved. In case of Sunnis, such conduct of the husband will amount to single irrevocable divorce and the marriage will dissolve automatically at the expiry of 4 months. In the case of Shias, the marriage does not dissolve automatically. Rather, it gives the wife the right of judicial divorce under Section 2, Clause 9 of the Dissolution of Muslim Marriages Act of 1939. Zihar. In this mode, the husband compares his wife to a woman within his prohibited relationship. Example, the mother or sister. The husband would say that from today the wife is like his mother or sister. After such a comparison, the husband does not cohabit with his wife for a period of 4 months. Upon the expiry of the said period, the zihar is complete. After the expiry of the 4th month, the wife has the following rights. She may go to the court to obtain a decree of judicial divorce. She may ask the court to grant the decree of restitution of conjugal rights, or where the husband wants to revoke Zihar by resuming cohabitation within the said period, the wife cannot seek a judicial divorce. It can be revoked if the husband observes fast for a period of 2 months, or he provides food to at least 60 people, or he frees a slave. Talaq-e-Tafwiz. It is known as delegated form of divorce and is recognized among both the Shias and the Sunnis. The Muslim husband is free to delegate his power of pronouncing divorce to his wife or any other person. He may delegate the power absolutely or conditionally, temporarily or permanently. A permanent delegation of power is revocable, but a temporary delegation of power is not. This delegation must be made distinctly in favor of the person to whom the power is delegated, and the purpose of delegation must be clearly stated. Any agreement made either before or after the marriage, providing that the wife would be at the liberty to divorce herself under certain specified conditions, is valid provided the conditions are reasonable and not opposed to public policy. Khula is a form of divorce with the consent of wife and at her own instance, in which she gives or agrees to give certain consideration to the husband for her release or redemption from the marital tie. The following conditions are necessary for a valid khula. There must be an offer from the wife. She gives or agrees to give consideration to the husband for her release, and the acceptance of the offer by the husband. Such proposal may be retracted by the wife at any time before the acceptance is made by the husband. According to Muslim personal law, a time of 3 days has been given by various jurists to both the husband and wife. The moment the offer is accepted by the husband, it stands a single irrevocable divorce. That is, their marital relationship ends the moment the husband accepts the offer. By mutual agreement or mubarat. Mubarat is also a form of dissolution of a marriage contract. It signifies a mutual discharge from the marital claims. In mubarat, the aversion is mutual and both the sides desire separation. Thus, it involves an element of mutual consent. In this mode of divorce, the offer may be either from the side of the wife or from the side of the husband. When an offer of mubarat is accepted, it becomes an irrevocable form of divorce, and the period of iddat is necessary. Judicial divorce is a formal separation between the husband and wife, where there is no direct role of husband or wife, but the court separates them according to the established custom or law. Under the Dissolution of Muslim Marriage Act of 1939, the legislature has made provisions for the divorce on the application of the wife. There are several grounds on which judicial divorce can be pronounced. Grounds on which a female can claim divorce under this act are when the whereabouts of the husband are not known, when there is failure to maintain for a period of 2 years, when the husband has been sentenced to imprisonment and there is a failure to perform marital obligations, impotency, insanity, leprosy, or a virulent form of venereal disease, the repudiation of the marriage, cruelty, false accusation of adultery, or the conversion of the spouse to another religion. I hope this video was helpful in providing a simple and clear understanding of divorce under the Islamic law. For any further queries, please drop your questions in the comment box below. Please like and share the video and subscribe to our channel.